All right, the next case to come before the court is James R. Fry et al. Versus Grace Speelman. It's case number 18AP0012. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as we will be keeping track of your time. The arguments are being recorded. Please keep your voices up, remain behind the podium. Prior to telling you we're ready to proceed, I know that there are cross appeals here. You need to handle your response to appellant and your cross appeals within your 15 minutes. You would not get an opportunity to rebut after rebuttal. Is that understood? Okay, I just want to make sure everybody understands before we proceed. The judges have read your briefs, and we are ready when you are. Okay.
May it please the court, my name is Aletha Carver, and I am here on behalf of appellant cross appellee Grace Speelman, and I would like to reserve 5 minutes for rebuttal, please. Mrs. Speelman respectfully asks this court to reverse the trial court's judgment, granting summary judgment in favor of the Frys under option 1 of the right of first refusal for several reasons. First of all, the Frys never requested relief under option 1 in their complaint. Second, the conditions of option 1 have not been satisfied. And third, granting relief under specific performance would be harsh and oppressive. Now, as this court is aware, it previously reversed the trial court's grant of summary judgment, finding that the Frys had never moved for summary judgment under option 1. And this simply is because they never asked for relief under option 1 in their complaint. So, to be frank, when this matter went back down to the trial court, I expected the Frys to move to amend their complaint under Civil Rule 15 and add option 1 as a basis for relief for specific performance. But that never happened. They renewed their motion for summary judgment. They argued again that they were entitled to summary judgment under option 2. And in the alternative, they asked that the court grant them summary judgment under option 1. The trial court granted them summary judgment under the first option, and now that we're here on appeal, the Frys are arguing that under Civil Rule 8A, we had notice. We knew what they were asking for in their complaint. There is no notice in the complaint, and I would direct the court to take a look at paragraphs 18 and 19 of the complaint. If you do that, you will see that the language and the relief that they're requesting mirrors the language under option 2. It does not mirror the language of option 1. Further, the Frys attempt to rely on the wherefore clause of their complaint, and they argue that that language somehow suggests that they wanted relief under option 1. But again, that language is even more specific, saying we should only have to buy the property for $25,000. And there's no doubt that that is the language under option 2. Now, Mrs. Speelman cites several cases in her brief that are directly on point regarding this issue. And the first case is the International Brotherhood of Electric Workers, Local Union Number 575. And in that case, the court held that a party cannot move for summary judgment on an issue that is not raised in a complaint. We also cite the United Brotherhood of Carpenters and Joiners of American Local Union Number 1581. And in that case, the court held that an award of summary judgment cannot be granted on claims not alleged in the complaint. Further, this court, in the Klukas decision that was issued recently, back in 2015, the court held that a summary judgment motion cannot be used to broaden claims beyond what is pled in a complaint. So all of these cases taken together stand for the point of law that they are not entitled to summary judgment under option 1 because Mrs. Speelman was never on notice that they were requesting relief under option 1. Now, the Frys only requested relief under option 2 because they only wanted to pay the $25,000 $25,000 for the property. They did not want to have to pay $84,700. Further, we would state that there is case law out there that talks about the parties being able to expand the relief that's requested in the complaint during a summary judgment briefing. And the parties can agree to address issues or address theories of a case or address claims that are not raised in a complaint. But that did not happen here. Mrs. Speelman specifically, on page 9 of her memorandum in opposition to the motion for summary judgment, brought this issue to the trial court's attention and said to the trial court, look, they've never pled this in their complaint. And that fell on deaf ears, and the trial court, as we know, proceeded to grant summary judgment. In both the United Brotherhood of Carpenters and Joiners case and the McGinnis case that I cite in the brief, the courts held that a court should not grant summary judgment in favor of a party who raises a new issue or claim in a motion for summary judgment where the opposing party did not consent to address this additional claim. Further, I would like to bring to the court's attention that the Fries never even filed a memorandum in opposition. We had filed also a cross motion for summary judgment. They did not file a memorandum in opposition to this argument or to our cross motion for summary judgment. And so this whole argument was never even addressed by the Fries at the trial court level. And this is the first time that it's being brought to this court's attention and it's being addressed. And it would be my position that that has been waived at this point by not being addressed at the trial court level. Now, as to Mrs. Speelman's second assignment of error, we rely on the law of the case doctrine and a specific case, the Burl-Camp Plastics case. And that case makes three important points when you're dealing with the law of the case doctrine. First of all, that case holds that the decision of a reviewing court remains the law of the case on all legal questions involved for all subsequent proceedings in the trial court and the Court of Appeals. Second, that case holds that the law of the case doctrine does not apply when subsequent proceedings involve an expanded record or different legal issues. And third point of law in that case, and the one that we're relying on here, is the statement by the court that the law of the case doctrine prevents a litigant from attempting to rely on a new argument on remand that could have been pursued in the first appeal. And so here, if it is indeed the Fries' contention that we pled this claim and we said we were entitled to specific performance under option 1, and if indeed this court finds that to be the case, then it is our position that the law of the case doctrine does not permit them to argue this now a second time around on appeal. Because they could have, theoretically, if they're saying that yes, we wanted relief under option 1, then they could have raised that argument a long time ago, and they did not do so. So we would ask the court to apply the law of the case doctrine and conclude that they should not be able to be granted relief under option 1 at this time. Now, as to her third assignment of error, Mrs. Speelman would like to address the option 1 itself and what was required to trigger that. And there had to be a desire to sell on Mrs. Speelman's part, and the Fries were required to provide her with written notice within 30 days of their intent to exercise the option. The evidence in this case, when you go back and take a look at the deposition testimony, indicates no desire to sell on Mrs. Speelman's part. And it was simply a transfer of property with donative intent. She did this because the Mowers agreed to take care of her into the future, had been caring for her following the passing of her husband, and that was the real consideration for this case. Now, there's evidence in the record that talks about the $25,000 purchase price, but there's also evidence that the Mowers never paid $25,000. There was never any money exchanged. There was never a note drafted showing a debt of $25,000. There was never a purchase agreement entered into. It was really all based on the fact that she was showing her appreciation of the Mowers caring for her during this period of her life. Also, we would point out that there was no bona fide price paid for this. Even at $25 or $25,000, this property is valued at over $81,000 by the Wayne County auditor. And so there's really a donative intent here. There was not a sale. And I was able to find a case, albeit out of Idaho Supreme Court case, that is almost exactly on point with the facts of this case. They're even interpreting the language desire to sell, the same language that we have here in option 1. And in that case, a father, there was a right of first refusal. A father transfers a farm to his son for $20,000, and the court ends up saying, you know, this did not trigger the right of first refusal because this property is worth 3 times as much, and it wasn't an arm's length transaction. It wasn't a sale. The court also found, as we have here similarly, that the son's promise to care for his mother into the future demonstrated a donative intent, and the Isaacson court ended up holding that where the lessor has indicated his desire to give and not sell the property subject to the right of first refusal. It cannot be said that the condition precedent to the ripening of the right of first refusal has been fulfilled.
Counsel, you're into your rebuttal time.
Oh, okay.
It's up to you if you want to continue. I just want to
I will just finish up then by saying that our final assignment of error just argues that granting specific performance in this case is harsh and oppressive. She never intended to trigger the right of first refusal, and the Fries cannot show that they were damaged. Because the right of first refusal, they rescinded the transaction. The property went back to Mrs. Speelman. She still holds it to this day. She still owns it, and there are no damages. It's in place. It can be exercised in the future. And then we would ask that the court reverse the grant of summary judgment in favor of the Fries and instead grant Mrs. Speelman's motion for summary judgment. And I'll sit down. Thank you.
Thank you.
May it please the court. My name is Sarah Baker, and I represent the appellees, cross appellants, James and Diane Fry. This case is really quite simple. Ms. Speelman willingly entered into a right of first refusal with the Fries, and after they complied with their end of the bargain, she chose not to uphold her end of the deal. Not once, but twice. First, she triggered option 1 under the right of first refusal when she intended to sell the property. And second, she triggered option 2 of the right of first refusal when she sold the frontage to the Mowers. While opposing counsel's attempts to seek sympathy for Mrs. Speelman, it should not be lost on this court that on page 51 of her deposition, Mrs. Speelman testified that Mr. Fry warned her she couldn't sell the frontage to the Mowers without violating the agreement. Instead of rereading the right of first refusal, she actively disregarded that warning. I'm going to briefly address the procedural arguments lodged by Mrs. Speelman in an attempt to avoid the merits of this case. Then I'm going to quickly move on to the merits of this matter. The Fry's renewed motion for summary judgment did not add a claim that was not pled in the complaint. As a threshold matter, the Fry's complaint sought a court order declaring that the Fry's are entitled to exercise their rights under the right of first refusal. That was contained in the prayer, and that's exactly what the trial court did when it granted the Fry's right to purchase the frontage under the terms of option 1 and complies with this state's liberal notice pleading standard. Counsel claims that the remedy of specific performance under option 1 was not pled in the complaint. Assuming the complaint failed to do this merely for the sake of argument, counsel still improperly conflates the equitable remedy of specific performance with the Fry's claim for breach of contract. The claim is for breach of contract, and that was properly pled in the complaint. The remedy is specific performance, and the equitable remedy of specific performance rests in the sound legal discretion of the court. In the complaint, paragraph 6 asserted that Mrs. Speelman entered into a right of first refusal and attached that contract as Exhibit 2 to the complaint. In paragraph 14 of the complaint, it asserted that Mrs. Speelman failed to give the Fry's notice required in the right of first refusal and the opportunity to exercise their rights in violation of her contractual obligations. Paragraph 15 asserted that Mrs. Speelman intentionally proceeded in contravention of those rights, and then in the prayer, it sought a court order declaring that the Fries are entitled to exercise their rights under the right of first refusal. Counsel's brief makes no attempt to address this language from the prayer, presumably because the request undeniably satisfies the notice pleading requirements and seeks exactly what Mrs. Speelman claims was not sought in the complaint. Similarly, the law of the case doctrine in no way precluded the Fries from seeking summary judgment as to option 1 on remand. As counsel stated during her argument, they rely on Burlingame Plastics and for the proposition that that case prohibits the pursuit of new argument, that the doctrine prohibits the pursuit of new arguments on remand that could have been raised in the first appeal. The doctrine does not apply because the merits of option 1 could not be heard on the first appeal, because this court is more than capable of interpreting its own decision, but it sent the issue of whether option 1 was triggered back to the trial. It didn't decide whether or not option 1 was triggered. That wasn't available to argue on appeal. Notably, the Ohio Supreme Court has stated in Nolan versus Nolan that the law of the case doctrine is a rule of practice, not a binding rule of substantive law, and should not be applied to achieve unjust results. The Supreme Court of Ohio went on to say, the purpose of the doctrine is to ensure consistency of results in a case by conclusively settling issues that have already been litigated. On remand, the Fries clearly requested relief under option 1, and Mrs. Speelman was provided with an opportunity to respond, which she did. Permitting Mrs. Speelman to procedurally bar this matter from being heard on its from being heard on its merits is the exact kind of injustice and application of this doctrine that the Supreme Court would caution against. Last, the Fries did not waive any arguments. The trial court properly denied Mrs. Speelman's motion for summary judgment, and the Fries were well within their rights to point out on appeal why the trial court was correct in that finding. Admittedly, the Fries would have waived arguments if the trial court had granted Mrs. Speelman's MSJ and the Fries had sought to appeal that. But the Fries aren't claiming any error on the part of the trial court with regard to its finding denying Mrs. Speelman's motion for summary judgment.
In that regard, are the Fries asking for specific performance or damages for breach of contract?
Well, Your Honor, they're asking for specific performance under the contract.
And if specific performance is to put them back in the position that they were in before the breach, are they not back in that same position after the transfer was rescinded?
Well, no, Your Honor, I don't think, well, certainly they're not in the same position because if it was triggered, well, can you repeat the question?
Sure. I mean, please don't read anything into the question.
No.
The problem is I don't mean to be obtuse, but there's not a conclusion inside this question. But if the request is for specific performance, and specific performance would mean put me in the same place I would be in had you not breached the contract, and the transfer has been rescinded. Are they still in the same place that they were in before the breach, assuming there was a breach?
No, Your Honor, because she triggered the agreement by having a desire. The simple desire to sell triggered the agreement. And so the position they would have been in had she not, regardless of whether she transferred the property and whether they transferred it back, her intent to sale would have triggered the option to purchase the property. And had she given them that opportunity, even before she transferred the property, they would have bought it. And she testified that she knew they would have bought it. And so the position they would have been in would have been she intended to sell it, and they exercised their option under option 1.
I have a question for you. You're saying that she intended to sell it. She says, I didn't intend to really sell it. I intended my grandson to take care of me as I get older. Is that a question of material fact the court needed to decide?
I don't think it is a question of material fact, Your Honor. I think that her affidavit that was submitted in connection with this case is very clear. The affidavit states in paragraph 18, she details the agreement between her and the Mowers. And it specifically says the agreement was the Mowers would pay Mrs. Speelman $25,000 for the frontage. That's all it says about the agreement. Paragraph 20 of her affidavit later details her motivation for selling to the Mowers, and it says Mrs. Speelman was willing to sell the property to Michael Maurer because of the care component. But nowhere in a review of the entire record will you find any instance in which there is testimony from the Mowers or from Mrs. Speelman that the agreement was that he would continue, that was part of the agreement. The continued care component was part of the agreement. You won't find that anywhere in the record.
Well, is there anything in the record about the possessory interest of the residents on that frontage? In other words, I from the briefs, I can't necessarily tell if there's, she testified she didn't agree to give up living, she's living on the frontage, is that correct? Or is this not?
Is there residence on that area?
Is there residence on that frontage?
Boy, Your Honor, I can't recall at the moment.
That's okay, it must not be germane, so it might have been just something in my ruminations about where we are with specific performances versus damages, so carry on, apologies.
Okay. So moving on to the substance, and I started to talk about option 1, but it's important not to lose sight of the agreement. The question before this court is whether Mrs. Speelman desired to sell the property to the Mowers. So it hinges on her desires, regardless of the ultimate nature of the transaction. And she conveyed her desires during her deposition. On page 20 of her deposition, she testified she told her kids she was going to sell the property to Michael Maurer. In paragraph 20 of her affidavit, she indicated she was willing to sell the property to Michael Maurer. When asked if she ultimately sold the property to the Mowers, on page 18 of her deposition, she responded multiple times, yes, I did. These are not my words, these are hers, and these are only 3 examples of many throughout the record where she states that she is going to sell the property. So regardless of whether the ultimate nature of the transaction ends up being characterized as something other than a sale, she intended to sell it. That's what she testified to, and that's what happened. Lending further support to this argument is that Mrs. Speelman intended to sell it, is the fact that she didn't treat the transfer as an exempt gift with the recorder's office. In fact, she paid the conveyance fees associated with the $25,000 purchase price. And that was attached, you can see that in Exhibit 5 to the complaint. This court should not be distracted by counsel's efforts to now characterize it as more of a gift than a sale. As stated previously, the lower court record will not reveal a single instance in which Mrs. Speelman or either of the Mowers refer to the sale of the property at issue as a gift. To the contrary, it's filled with multiple references of her intention to sell. Because Mrs. Speelman's desire to sell alone was sufficient to trigger her obligations under option 1, she violated the right of first refusal, and this court should affirm the trial court's finding that option 1 was triggered. Furthermore, because real property is at issue, specific performance is the proper equitable remedy. Mrs. Speelman's actions also triggered option 2 of the right of first refusal. As I previously detailed, the statements in her affidavit make it very clear that the agreement was that they would pay that the Mowers would pay $25,000 for the frontage. The motivation coming from the care component was not consideration. Ordinarily, consideration must be intended by the parties to serve as consideration. Furthermore, arguing it constituted consideration only undercuts Mrs. Speelman's argument that it was a gift. Mrs. Speelman makes much of the fact that the Mowers had not yet exchanged money at the time the Frys filed their complaint, but failure of consideration is simply not the same as no consideration, and the law is quite clear that a promise to pay constitutes sufficient consideration. Opposing counsel also cites a number of cases, Miracle, Park Station, and Hendricks, that are inapplicable because there was no consideration present in those cases. That's not the case here. Here, the transaction at issue falls squarely within the ordinary meaning of the term sale. Mrs. Speelman said she was going to sell the property to the Mowers, and they agreed to pay $25,000. She then transferred the property to them in exchange for their promise to pay. Opposing counsel argues for a definition of sale that would limit sales to arm's length transactions between unaffiliated parties. Such a definition is contrary to the plain and ordinary meaning of the term sale, but it also ignores the rest of the language contained in the right of first refusal. As this court is well aware, the Supreme Court has indicated that courts are to interpret contracts with a view toward ascertaining the intention of the parties and to give it effect accordingly. The right of first refusal lends itself to an interpretation that the parties intended the Frys to receive notice if Mrs. Speelman wanted to convey the property outside of the individuals listed in the agreement. Otherwise, the language in Section 2.02 of the right of first refusal would be rendered meaningless. Section 2.02 states in relevant part, notwithstanding the foregoing, a transfer, whether by sale, gift, devise, or inheritance, of all or a portion of the frontage to the children of the grantor or to grantor's granddaughter, Jennifer Vaca, shall be permitted and shall not be subject to this right of first refusal. Opposing counsel discussed the case from Idaho, in which that court determined that a transfer of property to a child for less than fair market value was more of a gift than a sale. But that case also stated that it was not a sale as contemplated by the lease. The language in that case, that as contemplated by the lease, is extremely important. In that case, the lease was different than the right of first refusal that's at issue here. It didn't contain language accepting certain people from the agreement, and in that case, it was given to a son. On page 454 of Isaacson, the court likened the transaction in that case to two other cases. One, where there was a conveyance to a family corporation controlled by the lessors, and another, where there was a transfer by a corporate lessor to another corporation controlled by the same owners.
Concludes your time. Counsel.
Okay, thank you, Your Honor.
Counsel, you have 4 minutes left.
Okay, thank you for apprising me of my time. To keep things moving, I just want to answer a couple questions that were brought up here during the opposing counsel's argument. Judge Hansel, you're correct. They are back to the same position that they would have been in had this never happened. And in fact, Mrs. Speelman actually, the Mowers transferred the property back to Mrs. Speelman before this lawsuit was even filed.
Well, counsel,
So-
what if, taking the other side's argument in terms of it was the desire that triggered, if the transfer hadn't even happened, but could she have presumptively breached by saying, I desire to sell, but no, I'm not going to follow through with this right of first refusal? Or is it the transfer that's the breach versus this desire to sell?
Well, I think the trial court found the transfer to be the desire to sell, but that's not our position, especially when you look at the Isaacson case that talks about looking at the nature of the transaction. And I know the Frys counsel said that you don't have to look at the nature of the transaction, but that is exactly what the 7th District Court of Appeals said in their case, that you should look at. You should strictly construe the language of the right of first refusal, and you should consider the nature of the transaction. So although option 1 says a desire to sell, when you dig back behind that and you see the facts that are going on behind the scene, I think you can come to the conclusion that she was not having a desire to sell like you would think as far as selling to a third party and putting the property out there that way. She was actually transferring the property more for consideration of the family member's care. So, now, to move on to the cross appeal, one thing I'd like to bring up, and this probably will in my opinion, really resolve this cross appeal is that this court, in the first go-around of briefing in the decision, Speelman 1, said that we're not even going to address option 2 because there hasn't been any meaningful comment on it by the trial court. And so this is going back, and we're going to give the trial court an opportunity to address this issue under option 2 before we do. And I've got to tell you, we're in the same position again here today. We don't have the trial court addressing anything under option 2 besides literally saying that they are going to deny as the primary branch, because that was their primary branch, option 2, and the court is saying, well, I'm going to deny the summary judgment. That is their primary branch, but I'm going to grant it under option 1. So really, we're back in the same position we were in the first go-around, and we still don't have a meaningful analysis from the trial court, and it's my opinion, in and of that in and of itself should be enough to say that you're not entitled to summary judgment on option 2. Now, be that as it may, I want to point out that what triggers option 1 and what triggers option 2 differ vastly in this case. Option 2 requires that the Fries offered option to purchase. They were offered the option to purchase, and that they did not act upon it or wish to purchase the property. At that point, then, Mrs. Speelman would have to go out and offer the property for sale to a third party. She would have to get a bona fide written offer from a third party. Then Mrs. Speelman would have to turn around and offer the property to the Fries. They would have to match that offer that she had received from the third party. So there is absolutely no evidence in the record at all that any of this went down as far as what was required to trigger option 2.
And with that, your time is
Okay.
concluded.
All right.
Thank you, counsel.
Okay, thank you.
All right, thank you both for your presentations today. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides, as well as posted on our website, and that of the Supreme Court. Thank you.
Thank you.